Good morning, sir. Can you see and hear us?
Yes, I can, thank you. Before you begin the evidence session, Ms. Price, I wish to make an announcement, all right?
Yes, sir.
It is with considerable regret and frustration that I have to announce that the session scheduled for Monday and Tuesday next week will have to be postponed. That is, Mr. John L. Singh will not be called to give evidence next Monday and Tuesday. I have reached the decision that his giving evidence next week is not possible because there is every likelihood that the post office will, in the course of the next either hours or days, disclose many documents which are relevant to him. My current understanding is that these documents may number in the hundreds, and it would clearly be impossible for Mr. Singh to receive those documents in time for him to give evidence on Monday and Tuesday, since as yet the inquiry does not have them. We had been promised by the post office that there would begin the disclosure of those documents, or disclosure of those documents would begin rather yesterday, but that has not occurred. And I am unclear as I speak as to when disclosure will begin. Fairness demands that Mr. Singh sees those documents before he gives evidence. Fairness also demands that co-participants see those documents before Mr. Singh gives evidence. And as I have said, the inquiry is not yet in a position to process those documents and disclose them to Mr. Singh and co-participants. Hence, to repeat, the sessions on Monday and Tuesday will not take place. It is also with considerable regret and frustration that I inform everyone that Mr. Gareth Jenkins will not begin his evidence on the 30th of November. In the case of Mr. Jenkins, the post office has disclosed 3,045 new documents, I believe yesterday, to the inquiry. The inquiry will need to process those documents and then disclose them to Mr. Jenkins and all other co-participants. Mr. Jenkins, as the inquiry was informed by his leading counsel, Miss Dobbins, has made a draft witness statement in respect of his evidence due to be given on the 30th of November. But that witness statement has not yet been signed, and it would be unreasonable of me to expect that Mr. Jenkins sign that witness statement until he has had the opportunity to digest all these new documents. I have taken the decision that it is practically impossible for the inquiry to be ready to receive Mr. Jenkins's evidence on the 30th of November, given this late disclosure. It may be, and I stress may, that the 4 days during which Mr. Jenkins was due to give evidence, beginning on the 30th of November, can be used for other witnesses. I will update everyone about that possibility as soon as I know whether that is a realistic possibility. So I would ask all participants in the inquiry to keep open the possibility that we will sit on the days designated between the 30th of November and the 6th of December, albeit that we won't be hearing from Mr. Jenkins. I should also say that given the obvious importance of Mr. Jenkins to my inquiry that I have decided that there should be a substantial period of time which should now elapse before I try to reschedule Mr. Jenkins. I cannot contemplate what has occurred so far recurring, namely that shortly before Mr. Jenkins gives his evidence, there is a flurry of activity which includes the late disclosure of documents. Accordingly, I have decided that some months are likely to go by before I call Mr. Jenkins to give evidence, because I want to be absolutely certain, or at least as certain as I can reasonably be, that every single relevant document relating to him has been disclosed to all relevant parties before his evidence begins. As I have said, therefore, it may be some months before Mr. Jenkins appears to give evidence at this inquiry. That is a source of frustration to me. I'm sure it will be a source of frustration to many co-participants, and perhaps a source of frustration to Mr. Jenkins himself. But I think everyone who has followed this inquiry will appreciate that it is crucial that Mr. Jenkins's evidence is heard with the benefit of all documents which is relevant to that evidence. To repeat, I am sorry to have to have made this announcement this morning, but I felt it necessary to do it orally as opposed to simply sending out a notice, so that A, everyone is clear about what I am saying, and B, those who are watching can see for themselves how frustrated I have become by all that is going on in relation to disclosure. Thank you, Ms. Price. You can now call your witness.
Thank you, sir. May we please call Mr. Whitaker?
Yeah.
I do solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth and nothing but the truth.
Could you confirm your full name, please, Mr. Whitaker?
Paul Graham Whitaker.
You should have in front of you a hard copy of a witness statement in your name, dated the 8th of October this year. If you can turn, please, to page 42 of that statement. Do you have a copy with a visible signature?
I do.
And is that signature yours?
It is.
Are there any corrections that you wish to make to the statement?
I'd just like to add that on recent disclosure, documents have become known to me. In this statement, I initially say that I wasn't aware of any challenge to Horizon right up until the time I left Post Office Limited in January 2012. However, I say these recent disclosures have shown that I was aware of some action in regard to questioning the integrity of Horizon, particularly in some post offices in North Wales, actually before I left. And it wasn't until I saw those documents that refreshed my memory.
With that correction made, are the contents of that statement true to the best of your knowledge and belief?
Yes.
For the purposes of the transcript, the reference is WITN 050-50100. Thank you for coming to the inquiry to assist it in its work and for providing the witness statement that you have. As you know, I will be asking questions on behalf of the inquiry. Today, I'm going to be asking you about issues which arise in Phase 4 of the inquiry, focusing on your involvement as an investigator within the Security and Investigation Team in the relevant criminal prosecutions, including the prosecution of David Blakey. You joined the Post Office in 1985 as a postal cadet, is that right?
Correct, yes.
And from 1986 to 1994, you worked as a postman delivering and processing the mail?
Yes.
Between 1994 and 1998, you worked within Royal Mail Letters, dealing with postal franking machines in the main.
Yes.
Then in September 1998, you joined the Post Office Security and Investigation Service, as it then was.
Yes.
And your role was initially that of an assistant investigation officer, is that right?
Correct, yes.
Can you explain, please, the three separate entities which existed at that time under the Royal Mail Group corporate umbrella?
There was Post Office Limited, Royal Mail Letters and Parcel Force.
You say in your statement at paragraph 8 that Royal Mail Letters and Post Office Limited each had their own investigation function, but Parcel Force did not. So in 1998, the Post Office Security and Investigation Service had parcel group sections which dealt with investigations into crime within the Parcel Force network. Is that right?
That's correct.
You deal with your role within the Post Office Security and Investigation Service at paragraphs 9 to 11 of your statement to the inquiry. Could we have those on screen, please? It's page 3 of Mr. Whitaker's statement, WITN 050 50100. And starting at paragraph 9, you say this: on joining POSIS, I recall that I had an initial period of induction training which covered relevant aspects of investigation, e.g. law, principles of investigation, evidence gathering, PACE, etc., before being assigned to an established officer for on-the-job training. Further training modules were completed over the following year in subjects such as witness interviewing and suspect interviewing, etc. As I recall, I received no specific training to do with POL work at this time. As within Parcel Group, I was not expected to undertake or assist with any POL investigations. You go on at paragraph 10. In 1999, Parcel Force introduced its own investigation function, and in September of that year, POSIS Parcel Group North was disbanded. Its operational staff in Leeds were then compulsorily transferred to different Royal Mail investigation functions. Some staff went into Parcel Force and others to Royal Mail Cash Co, the Royal Mail Group's cash carrying function. Despite having a background in mails work and no previous POL experience, I was sent to work for POL, initially based at their regional headquarters in Leeds in September 1999. Going to paragraph 11, please. I had no say whatsoever in where I was placed at this time. How did you feel about being sent to the Post Office Security and Investigation team in 1999?
I recall a certain amount of apprehension for the reasons stated in the statement. I'd not worked behind a post office counter at that time. However, obviously I was happy to go wherever they sent me.
You worked as a Post Office Investigation Manager, later named a Security Manager, from 1999 until January 2012, save for a brief period when you were a temporary team leader for the South Investigation Team in around 2009. Is that right?
Yes.
And then in 2012, you took up the role of Investigation Manager with Royal Mail Letters.
Yes.
You say in your statement at paragraph 13 that when you were a Post Office Investigation Manager, Post Office security was split into 3 areas: East, West and North. Is that right?
That's as I recall it, yes.
And which was your area when you first started as an Investigation Manager?
The North.
And where were you based at first?
Initially I was based in Leeds.
And what part of the country were investigations run from the... What part of the country were investigations covering out of the Leeds office?
It was the investigations in the counties in the sort of northeastern quadrant of England. So up to the Scottish borders around Berwick and down as far as sort of just south of Sheffield, that sort of area, and across to the east coast.
And who did you report to when you were based at the Leeds office?
Initially, my first team leader was a gentleman named Les Thorpe.
And he was based in Durham, is that right?
I think it was Peter Lee, yeah, County Durham, yeah.
Mr. Thorpe, in turn, reported to a senior investigation manager based in Glasgow, Rashid Sarwar, is that right?
As I recall, yes.
Who in turn reported to the North Area Head of Security, also based in Glasgow, and you say that was a man called Duncan McFadden.
I believe so, yes.
You say in your statement that the security department was split into physical security and investigation departments, and it was the latter of these which you worked within, that being the teams responsible for the investigation of suspected criminal losses to the post office.
Correct.
You say in your statement at paragraph 16 that perhaps a year after you joined the post office, the security function within the post office began a period of rapid change. Can you explain, please, the key changes which were brought in at that stage? Please do feel free to refer to your statement if you need to.
If I may. Yeah, as I recall, there was a number of geographical boundary changes and staff changes as well, movement of staff. I mean, I do recall actually at that time I spent some time doing some investigations in the northwest, and in terms of hierarchy, I'd say at the time Tony Marsh headed it, and Phil Gerrish became his head of investigations. So I believe at that time Mr. Thorpe went, and I recall the sort of line for investigations became more sort of centred around Mr. Gerrish being the head of the investigation function. I can't recall Mr. McFadden or Mr. Sarwar having much input around that time. As I can't recall specifics, but I do recall that there seemed to be plenty sort of happening, as it were.
And as a result of those changes, you moved from being based in Leeds to being based in Sheffield, is that right?
Yes. But I was on my own in Sheffield. It wasn't that there was an office in Sheffield that moved from Leeds. It's just that I happened to work from an office in Sheffield.
And is it right that your manager was never based in the same location as you in Sheffield?
No, that's correct. Yeah.
But you say you saw them regularly and were in contact by email and telephone?
That's correct, yes.
You recall Tony Marsh leaving the post office to become head of Royal Mail Group Security in around 2007?
Yes.
And Phil Gerrish leaving shortly thereafter to join Royal Mail Letters as head of investigation?
Yes.
How did the post office security team change under the leadership of John Scott, who replaced Tony Marsh?
John Scott brought in more of an ethos of analysis in regard to losses. It was more proactive and on the front foot, looking at ways to stop losses, and less focused on reactive investigation once losses had occurred. Within that, he reorganised. He brought in sections that, as I say, looked at forecasting, if you like, and using techniques to be able to anticipate where losses might occur, as opposed to just straight investigating losses reactively once the loss had occurred.
You say in your statement that you also noticed a change in the type of experience which your investigation colleagues had. Can you explain the nature of this change, please?
Yeah, I think Mr. Scott wanted to bring in security managers that were potentially dual trained, so they were not just investigators. As I said, they had more background in looking at proactively looking into losses and also into physical security. So we're looking at dual training the managers. And I think during that time, because of the people that he brought in, who may have been more attuned to that new type of role, I think we lost a lot of experience in regards to actual investigators and people who were able to work to reactively investigate a loss.
What happened to the geographical remit of the security team in general and in relation to your team in particular under John Scott?
It just widened. It went from just being in the north. I was coming down to London. I was taking on investigations in Wales. So it just widened. I think there were at different times different geographical barriers were brought in. But they did change quite a lot.
And you say at paragraph 22 of your statement that the remit went expanded into Scotland and Northern Ireland as well.
Certainly, yeah, I did investigations or assisted with investigations in Northern Ireland and in Scotland.
You deal at paragraphs 23 and 24 in a bit more detail with some of the changes in approach to investigation brought in by John Scott. Could we have those paragraphs on screen, please? It's page 7 of WITN 05050100. You say here, I feel that Mr. Scott focused more on bringing Pole security a data-driven model to proactively analyse and seek out risk and loss within post offices, as opposed to using the Pole investigation team to investigate losses reactively. Mr. Scott brought in much more data analysis in his loss management strategy and set up a dedicated team to do this. I recall Helen Rose being part of that team, but unfortunately cannot recall other names. What and who do you understand was driving the new approach of proactively analysing and seeking out risk and loss within post offices rather than investigating reactively?
Certainly Mr. Scott was driving that, John Scott. His reasons why he was doing that, I'm only speculating in that potentially an investigation team were expensive. Essentially, what he could have looked at what value they did actually bring to the organisation. Pole was changing very, very quickly around that time, I recall. The network was shrinking. They'd lost a number of contracts. They were examining how they worked and where they sat within the country, and how they were to operate going forward. So I think, and again, it's only my speculation of how I looked at it. I think it was to do with that and looking at repositioning the organisation, and as I say, an investigation department, a purely investigation department, was an expensive tool, perhaps.
At paragraph 24 of your statement, you say this: Mr. Scott also brought in a team to try to recoup losses through the Proceeds of Crime Act, and some investigators were trained as financial investigators. From memory, I recall these included Jed Harbinson, Graham Ward, Helen Dickinson, and Paul Southern. Do you recall where the agenda for recouping losses through criminal enforcement proceedings came from?
Again, it could be speculation because I don't recall ever being told, but I believe that obviously in order to enact the Proceeds of Crime Act and to use the Proceeds of Crime Act, there has to initially be a crime committed. So I think it was. In fact, that was probably one of the reasons why elements of the investigation team remained. But ultimately, I think Mr. Scott was all about affecting the bottom line of the organisation and trying to stop losses. So that was a strategy brought in regard to that. Whilst I understand that in terms of the proceeds of crime, an element of that, any money recouped would go to the government, also some would not.
You refer to the bottom line of the business. Did you ever feel that the interests of the business, particularly financial interests, influenced the way investigators did their job?
It certainly didn't influence me at all. I never gave it a thought.
Going over the page, please, to paragraph 28 of the statement. You say this: I felt that within the tenure of Mr. Marsh as head of security, I found the line management within Pol investigation to be supportive and experienced, with many of the managers having come through the ranks, as it were. They knew the investigator's role and the challenges it brought. However, I feel that when Mr. Marsh and others left Pol, my line management under the leadership of Mr. Scott, though reasonable in so much as they were someone to manage staff, many lacked the experience and understanding within the investigation and criminal justice fields. Managers I remember and consider in respect of that statement were Andrew Daly and Alison Drake. Did this lack of experience and understanding within the investigation and criminal justice fields have an impact on the fairness and adequacy of investigations, in your view?
Not personally, I don't think, because I think when that came in, I was of a not of a standing, but I had enough experience of the job to be able to work through that. But anybody who came in to an investigator's role or a role that had an investigation element, they may have felt they may have struggled somewhat with line management and leadership who didn't fully understand the role.
How did the various investigation teams operating across the country communicate with each other about any matters of concern arising on their patch?
All sort of communication tended to come from the centre, as it were. We did get together occasionally for conferences and such like, at which things would be chatted through, and I did feel that I could speak to investigators throughout the country if I wanted to and ring them up. But essentially, a lot of the information of which you speak there would come from the centre, so it would feed in from someone on the south coast or something, and it would get up, if relevant, if deemed relevant by whoever was disseminating it, it would get disseminated out to everyone else.
Why did you leave the post office to go to Royal Mail Letters?
I think I was getting a bit disillusioned with Post Office Limited. I was not particularly a fan of the leadership. As I said, the organisation was going through a lot of change. I thought there was slightly more job security in Post Office Limited, and a job came up in there, so I applied for it and got it.
Turning to the training you received in the conduct of investigations, please. Before you joined the Post Office Security and Investigation Service in 1998, did you have any experience in criminal investigations or criminal law?
Not directly. Elements of the job within the franking machines, there was elements of inspection and that linked into elements within POSIS, but not directly as an investigator or within that sort of field.
We have seen from paragraph 9 of your statement, which we had on screen earlier, that you had some initial induction training when you first joined the Post Office Security and Investigation Service in 1998. How much time did the initial induction training take up?
I recall it was 2 weeks residential training in Croydon.
You say in paragraph 34 of your statement that this was classroom-based learning. Who was it who provided this training?
It was, I think there was an in-house training group within POSIS, and it was their trainers that did that.
You've said already that the training did not cover post office investigation work, as within the parcel group you were not expected to undertake or assist with any POL investigations. But you say there were further modules covered over the course of that first year in investigations when you were allocated to parcel group work. And you give examples of the topics covered in your first year as suspect interviewing, witness interviewing, searching and report writing in your statement. Did any of the training you did in your first year cover disclosure?
I don't recall that it did.
You say at paragraph 9 of your statement that you were assigned to an established officer for on-the-job training. How long did this on-the-job training last for?
It lasted for a year, I believe.
Can you recall now what kind of work the person you were shadowing was doing in that first year when you were still with parcel group work?
He was leading investigations in the main parcel force losses.
And how did parcel force losses differ from those you dealt with later with the post office?
There were very much losses from the course of post, so examining the theft of parcels from course of post. In fact, that was the main body of the work. The old charge of delaying the mail. That was one that was looked at. There were a couple, I think, because part of the remit of Parcel Group was also to do group inquiries. So anything that came under the Royal Mail Group that didn't fall within letters or anything like that tended to get sort of handed to Parcel Group to pursue. But it was certainly nothing that was in any way accountancy based or anything like that.
You say in your statement at paragraph 35 that when you were moved to Post Office Investigations in 1999, you were given some counter-clerks training on the counter-clerk role and Post Office working practices. And that was before the introduction of the Horizon system, wasn't it?
I recall that it was, yes.
When you were moved to Post Office Investigations in 1999, were you given any training, in particular on your duties as an investigator working on Post Office, as opposed to Parcel Group investigations?
I don't recall any specific training where I was taken to one side and says, this is the training that you're about to receive. I was placed under this sort of tutorship, if you like, of a long-standing investigator and another investigator who were very experienced, and I was sort of mentored, if you like, though it was never officially called mentoring, in regard to those sort of taking me along and introducing me to the work.
And who were those more experienced investigators?
John Hart was the most experienced one, and then John Hart, and John Downey, he was an assistant investigation officer at the time, with, as I say, John Hart being the lead investigator, if you like.
You say at paragraph 36 of your statement that when the Horizon system was introduced, you recall going on a course over a week or so on the Horizon system. Is that right?
Yes.
And that training was not specifically for investigators, there being other post office staff on the course, including sub-postmasters.
Yeah, I recall it was I was sat amongst some postmasters, other post office staff. It wasn't exclusively investigation based.
Did you have any training on the Horizon system after this?
Not that I can recall.
You say in your statement at paragraph 32 that in around 2006 you completed a Level 4 National Vocational Qualification in Investigation Management. Can you recall what topics you covered during that qualification of relevance?
Again, it was a vocational qualification, so it was demonstrating competency in interviewing, witness interviewing, managing investigations, those sort of modules. Again, there was nothing specific about Horizon or anything in there.
You also say that before you left the post office, in 2010, you started a postgraduate diploma in security and risk management at Leicester University, which you completed after you had moved to Royal Mail. Again, can you remember any relevant topics that you covered when doing that training?
In regards to investigation, there was a topic around the law, but it wasn't a specifically an investigation-based course. As I say, it was security and risk management, so it was more in keeping with, I suppose, Mr. Scott's view about looking at risk management within the organisation.
Turning then to policies and guidance applicable to the work of post office investigators, were any investigation or prosecution policies provided to you during the training you had in your first year as an investigator in 1998?
I recall policies would have been available. I don't recall an online. I don't recall a sort of repository. So I would imagine they would have been available for us to look at and expected that we had a knowledge of them.
You say you think they would have been available. Where do you think they were available?
I'm just trying to think, because 1999, it may not have been online. In 1999, when I was working in Parcel Group, we were actually in an office, and there was a number of us in there. So they may have been available in there, possibly in binders or something like that. But I can't recall, to be perfectly honest.
Were any investigation or prosecution policies provided to you when you moved to post office investigations in 1999?
Not specifically. Again, because I was working in Leeds, which was a sort of regional office, there may have been available within the office somewhere, but I don't specifically recall that, yes, they were in the third cabinet from the left or anything like that.
Could we have on screen, please, paragraph 38 of Mr. Whitaker's statement? That's page 11 of WITN 050500100. You say here at paragraph 38, I don't recall there being a central repository or such where investigators could specifically view policies. The dissemination of information contained within policy, as I recall and understand, was mainly through training, team meetings, and special directives called investigation circulars, which would be sent via email to investigation staff. Can you recall when email investigation circulars were first introduced?
It was very, very early on. It may have been around 1990. That may have been earlier. But I do recall them occasionally coming out and saying, investigation circular D15 or whatever, and whatever it referred to.
And these circulars, were they summarising what was in a new policy, for example, or were they attaching the policy itself?
I seem to recall that they were summarising. It would be new policy or changes within the law, or I suppose anything that because I think they were issued centrally through group security. So it would have been anything that group security felt the need to disseminate officially in one of these documents. So.
Can we have on screen, please, document reference POL 001 04762? This is a document entitled Disclosure of Unused Material, Criminal Procedures and Investigations Act 1996 Codes of Practice, and it is dated May 2001. This is one of the policy documents which was sent to you by the inquiry for the purposes of preparing your witness statement. Have you had an opportunity to read this document?
Yeah, I've looked at the document, yeah.
Had you seen this document before the inquiry sent it to you?
I don't recall. However, if I had, it would have been almost 20 years ago.
Under purpose, this document explains that the aim of this policy is to ensure that security managers know and understand the investigation procedures in relation to the disclosure of unused material, as described in the Criminal Procedures and Investigations Act 1996 Codes of Practice, which must be adhered to by all consignia staff undertaking investigations. Just pausing there, you listed the Criminal Procedures and Investigations Act as governing your role as an investigator at paragraph 39 of your statement. Were you aware in 2001 that there was a CPIA code of practice which post office investigators were required to adhere to, in addition to the Act itself?
I'm not sure if you'd asked me at the time that I would be able to say, yes, I am adhering to the CPIA Code of Practice. However, my understanding was that generally that we would. I don't know if that makes sense. You know, if someone were to have asked me then, are you adhering to this? I would say, well, I believe I am. But if they would have asked me to sort of stand there and recite the Act, I don't think I would have been able to do it.
The introduction at 3.1 in the first two bullet points identifies the Act, so the Criminal Procedures and Investigations Act 1996, and then also covers the Attorney General's guidelines on the disclosure of unused material. Maybe that you can't say, but in 2001, were you aware of the existence of the Attorney General's guidelines on disclosure of unused material?
Well, I can't say. However, in 2001, I would have probably been sort of 15 months into the role and quite new. So there's a strong chance that I wouldn't have been.
Going further down the page, please, to the General Principles section. There is a section on investigators and disclosure officers. And at bullet point 1, an investigator is defined. An investigator is a person involved in the conduct of a criminal investigation involving consignia. All investigators have a responsibility for carrying out the duties imposed on them under this code, including in particular recording information and retaining records of information and other material. Then at the second bullet point we have this: investigators and disclosure officers must be fair and objective and must work together with prosecutors to ensure that disclosure obligations are met. A failure to take action leading to proper disclosure may result in a wrongful conviction. It may alternatively lead to a successful abuse of process argument or an acquittal against the weight of the evidence. Then at bullet point 3, we have this: in discharging their obligations under the statute, code, common law, and any operational instructions, investigators should always err on the side of recording and retaining material where they have any doubt as to whether it may be relevant. Moving then to the second bullet point on this page. The disclosure officer is the person, going up a little. The disclosure officer is the person responsible for examining material retained during an investigation, revealing material to legal services during the investigation and any criminal proceedings resulting from it, and certifying to legal services that he has done this. Normally, the investigator and the disclosure officer will be the same person. Just pausing there, you've addressed in your statement your understanding of your role in relation to disclosure at the time of your involvement in Mr. Blakey's case, that is in 2004. Could we have on screen, please, paragraph 139 of Mr. Whitaker's statement? That's page 33 of WITN 050-50100. It's 139. You say this: regarding disclosure, without really knowing it, I was the disclosure officer in the case. Within POL investigations, if you were the officer in the case, you were also disclosure officer, exhibits officer, report writer, witness liaison, and all the other roles combined to support an investigation. As such, when it came time to review evidence and produce disclosure schedules for a criminal prosecution, it was down to each investigator to do this. You say you were the disclosure officer without really knowing it. Do you mean by that it fell to you to complete the disclosure schedule as one of a number of tasks investigators did, but you gave no conscious thought to the fact that you had an additional but distinct role as a disclosure officer?
No, what I meant by that was that basically you were expected to do everything. It was never said to me that you are the disclosure officer, but I knew I had disclosure fell under the remit of what I was expected to do. So it was simply that I, as a post office investigator, you were expected to do everything. I know in other roles in other organisations, the roles that I've mentioned there, exhibits officer, report writer, would often be someone different, and an investigator would stand to one side of them, leading the investigation. But within every one of my post office limited investigations, no matter how big or small or how complicated or how simple, those roles were expected to be completed by the investigation manager.
So you knew that you had a disclosure task, but were you consciously aware that you had a distinct role with applicable additional duties as a disclosure officer?
I don't think it was ever pointed out to me that you are disclosure officer. It's not a role or a term that I probably would have been familiar with. However, as you say, I knew I had a role in regards to providing disclosure and considering disclosure all the way through an investigation.
Going back, please, to the May 2001 disclosure of unused material policy, that's POL 001 04762. Page 2 of that document, please. The third bullet point on this page, about halfway down, deals with a section 9 statement, and underneath that, underneath the paragraph in bold, it is explained, in meeting the obligations in paragraph 6.9 and 8.1 of the Code, it is crucial that descriptions by disclosure officers in non-sensitive schedules are detailed, clear and accurate. Then this at the next bullet point. Disclosure officers must specifically draw material to the attention of the prosecutor for consideration where they have any doubt as to whether it might undermine the prosecution case or might reasonably be expected to assist the defence disclosed by the accused. At the time you were an investigator, did you understand that because you were also the disclosure officer, you had a duty specifically to draw material to the attention of the prosecutor where you were in any doubt as to whether it might undermine the prosecution case or assist the defence?
I recall that I would have been aware of that because in filling in the disclosure schedules, it specifically mentions that. So I think it's safe to say that I would have had an understanding that that was something that I should have been doing.
The bullet point below says this: disclosure officers must seek the advice and assistance of prosecutors when in doubt as to their responsibility, and must deal expeditiously with requests by the prosecutor for further information on material which may lead to disclosure. Who was the prosecutor in cases you investigated on behalf of the Post Office?
Would have been Legal Services, Royal Mail Group Legal Services.
And is it Legal Services, that criminal law team, that you would have gone to if you were in doubt about your responsibilities relating to disclosure?
Probably in the first instance, if I had any doubts about it, I may have chatted it through with team leader or something like that, or a colleague. My view with regard to it was essentially that my role was to, in disclosure, or certainly a role in disclosure was to list everything. It was going to get reviewed, and if there was anything that that shouldn't have been there or was on the wrong schedule or any issues like that, the reviewing lawyer would get back to me, and it would be, it would be discussed and put right. That's how I viewed the process, or as I seem to recall how I viewed the process.
It is not referenced in this document, but were you aware when you were an investigator that there was an obligation on a criminal investigator to pursue lines of inquiry which pointed away from the guilt of the suspect?
Yes.
In terms of the legislation you list at paragraph 39 of your statement, which you say governed your investigations, and do feel free to refer to that if you want to, where would you have found these documents if you wanted to refer to them?
The Police and Criminal Evidence Codes of Practice, they were in a book that we carried around with us. The Criminal Procedures and Investigation Act, potentially as it went along, they could have been along. They could have been held electronically. Human Rights Act, I recall when that came in, we went on a course. But again, I would imagine they would have been held somewhere, the specific acts, or you could get them from from open sourcing on the government website, and so a number of places they would be available to be viewed.
Apart from the Police and Criminal Evidence Act, which you say you carried around with you, did you ever go directly to the other legislation for guidance?
Potentially, maybe the Proceeds of Crime Act, but I would probably be more inclined if I had a query that fell within those. I would have rang Legal Services. I would have rung a lawyer. My view was that they were the experts. If I got a query in regard to specifics of the law, I would ring them.
You have recently been provided with some documents by the inquiry relating to training provided very shortly before you left the Post Office to join Royal Mail in November 2011. And that was training on legal advices and disclosure, which was provided by Rob Wilson, who was head of criminal law at that time, and counsel from a set of chambers specialising in criminal law, hosted externally by that set of chambers. Could we have on screen, please, the email invitation to this training? The reference is POL 001 67351. We can see this is an invitation from Graham Brander to a session planned from 11 a.m. to 3 p.m. on the 14th of November 2011. So I think you left the post office in January 2012, is that right?
Yes.
So some 2 months later. As far as you can recall, did you go to this training session?
I vaguely recall coming down to, I think it was held in Chambers, close to the Royal Courts of Justice in London. I'm not sure whether that was this course or another, but I've got no reason to believe that I wasn't, that I didn't attend if I was invited to.
Can you recall being on a training course where disclosure was specifically discussed?
Again, I think I'll have to refer back to what I've just said. I do recall having some sort of training within Bell's Yard, but I'm not entirely sure that it was disclosure. It could have been something else.
Can you recall attending any training specifically on disclosure at any time before this, whether provided internally by the post office or otherwise?
I don't, but again, that's not to say that there wasn't. There could have been something right at the very, very beginning. But I think, and I don't know whether it's something that'll be mentioned later. I do think the provision for training in respect of disclosure within Post Office Limited was not what it should have been.
So, are we right to understand that you have a memory of there being some training provided by an external provider?
Not specifically disclosure training. I do remember that from time to time external providers would give us training, and as I say, I do remember some training in Bell's Yard, Chambers. However, I genuinely cannot recall if it was disclosure training, if it was training on something else. Unfortunately, the reason I do remember it, because I do recall that we were shown around the Royal Courts of Justice afterwards. So I do recall we were down there, and I recall that happening, but the actual content of the training, I can't recall whether that was disclosure training or not, unfortunately.
Setting aside the content of the training, is there only one occasion you remember where you were given training by an external provider?
Yeah, probably. Yeah.
We need not have them up on screen unless you wish to go to them, Mr. Whitaker. But among the documents recently provided to you are 2 emails sent to you and others after this training, which included the PowerPoint presentation from the session, an extract from the criminal procedure rules, the code for Crown prosecutors, and the CPIA Code of Practice, as well as links to other CPS resources, including the Attorney General's guidelines on disclosure. As far as you can recall, do you remember receiving those documents by email?
I don't remember receiving those documents, but if they were sent to me, I would have received them.
Can you recall ever being sent those kind of resources before this?
What, specific to disclosure?
Well, the resources I've just referred to, and in particular, the Attorney General's guidelines on disclosure, the CPIA codes of practice, the code for Crown prosecutors. You were being sent these documents after this training. Do you remember those documents ever being sent to you before?
No.
You say in your statement at paragraph 33 that you felt the training in respect of the investigation role you held was adequate, that you were trained to a reasonable standard in investigation skills, and any specific major change to the law, policies, or techniques would be communicated through training courses. But your assessment of the training relating to disclosure is somewhat different. Could we have on screen, please, paragraph 140 of Mr. Whitaker's statement? That's page 34 of WITN 05050100. You say here, an issue that I feel there was that there was no regular refresher training on the subject, that subject being disclosure, is that right?
Yes.
Often the line managers were equally as poorly equipped to deal with disclosure, and because as poll cases were rarely committed for trial, consideration and production of schedules was something that investigators rarely did. I can recall in my time at Poll investigators with substantial service who had never assembled what was known as a committal file and therefore had never produced disclosure schedules. Does this remain your view that because there was no regular refresher training on disclosure and because post office cases were rarely committed for trial, investigators and their line managers were poorly equipped to deal with disclosure?
I would agree with that. I mean, reading out the policy, essentially, Post Office Limited said this is the policy that you're adhering to, and obviously the law with regard to what you're adhering to with disclosure. However, there was never any, or I don't recall any checking of understanding of that. It was never something that was really pushed, as it were. And I don't know whether that is because we were, as said in the statement, we were rarely called to put together schedules and actually seriously consider disclosure ahead of proceedings. I think the general feeling was that with disclosure is that we were, we had a duty to retain, we had a duty to review, but actually putting the schedules together was something that was rarely done, and I don't recall getting any feedback. When they were sent into review, I don't recall getting any feedback to say, oh yeah, they're fine, or they're not what they should be. So essentially, that's the knowledge that I've sort of drawn to make the statement that I've made in my statement.
Sir, I am about to move to a larger topic. I wonder if we might take the morning break slightly earlier.
Yes. Yeah, by all means, Ms. Price. So what time should we start again?
11:30?
Yeah, fine. Thanks.
Thank you, sir. Hello, sir. Can you see and hear us?
Yes, thank you.
Mr. Whitaker, I'd like to turn to investigation casework compliance. Should we take it from your statement that there was, throughout your time as a post office investigator, a requirement that certain information was set out in the case files in a uniform way?
Yes.
One document which the inquiry sent to you for the purposes of preparing your statement was a document entitled Casework Management, and there are two versions of that. One is dated March 2000 and one is dated October 2002. It's right, isn't it, that you don't recall being provided with either version of this document before they were provided to you by the inquiry?
I don't think they were provided to me. I don't know whether I would have been able to access them, but not actually provided.
Is their content familiar to you?
Yeah.
This document sets out the need for two separate reports. One, the conduct report, to go to the discipline manager, and another, the legal report, to go to the criminal law team. Sensitive information should only be included in the legal report and not the conduct report. And there are also paragraphs in this document dealing with both operational and procedural failures identified during an investigation. Is that a fair summary of the nature of the document?
Yes.
You've provided in your statement your understanding of the guidance given in that document, and this is at paragraphs 72 to 73 of your statement. Is it right that your understanding of the guidance now contained within that document is this: within disclosure, the organisation should take care, as evidence and unused material may contain commercially sensitive information that should not be in the public domain? Do you want to have a look to your statement? This is paragraph 72. We can have this on screen if that's easier. WITN 050-50100, page 19. This is a document that the inquiry is familiar with. If you'd like to refresh your memory, I can bring that up on screen for you as well, or are you content to go from your statement?
No, I'm content to go from my statement. Yeah, my understanding of the guidance and how it was applied at the time was, as I've said in my statement there, that the commercial sensitivities were to do with customers of the post office and how their transactions move through sub-post offices. And my understanding was that anything commercially sensitive from that point of view was what this guidance was aimed at. I didn't take it that this guidance was aimed at the relationship between Fujitsu and Post Office Limited. I thought purely it was to do with, I think I've mentioned it in the statement, such things as the benefits agency and how their products were processed through post offices.
In terms of your understanding at the time you were an investigator, did you think that because something was commercially sensitive, that alone and of itself meant it did not need to be disclosed?
No.
You say at paragraph 76 of your statement that towards the end of your time with the post office, you recall there being a push on casework compliance.
Yep.
And you recall a compliance checklist being sent out and files being scored against that checklist by a compliance manager.
Yes.
And you recall that compliance manager to have been Jed Harbinson?
Yes.
Could we have on screen, please, document reference POL 0011 8096? The email about halfway down the page on this document, please. A little further down. This is an email from Dave Posnett to a number of security team recipients, including you, and it's dated the 23rd of May 2011. The subject of the email is casework compliance, and the email reads as follows. Most of you are aware that case files submitted for legal advice will become subject to compliance checks. This process is due to commence in June and is designed to raise standards of files submitted, including their contents, reports, tape summaries, appendix enclosures, recoveries, stakeholders, etc., and ensure there is a consistent approach across the team. It is also probably an opportune time, given that we have recently recruited new people to the team. I've associated relevant documents that feed into the compliance process. Please familiarise yourself with these documents. A number of compliance documents were attached to Mr. Posnett's email in a zip file. Presumably, given the instruction in Mr. Posnett's email to familiarise yourself with the documents attached, you read them when you received his email, did you?
Though I can't recall reading them, I can't think of a reason why I wouldn't have.
One of those documents was the Guide to the Preparation and Layout of Investigation Red Label Case Files. Could we have that on screen, please? The reference is POL 0011 8101. Just scrolling down a little. Did you read this document at the time it was sent to you by Mr. Posnett? Or can't you say?
Is it possible to scroll down a little further, because I can just see a blank page?
We can look over to the second page, and that may give you a bit more content.
Right. As I say, I can't think of a reason why I wouldn't have, although if you asked me what date, what time I read it, I wouldn't be able to tell you.
This document deals with the content of the offender report and the discipline report. So we discussed just now the separate reports that were required by the casework management document, one being the one for the criminal law team and the other being the conduct report. So the terminology is a little different, but it is the offender report, which goes to legal, and the discipline report, which goes to the discipline manager in sense of this document.
Yes.
This was provided to you by the inquiry. Have you had a chance to read it?
Yes.
You address this document at paragraphs 78 and 79 of your statement, so please do have those in front of you if you need to refer to them. Can we turn, please, to page 10 of this document? Scrolling down a bit, please, so that 2.15 is visible. And to put this in context, this is the second section of the report dealing with the content of the discipline report as opposed to the confidential offender report. And paragraph 2.15 reads as follows. Details of failures in security, supervision, procedures and product integrity. This must be a comprehensive list of all failures in security, supervision, procedures and product integrity. It must be highlighted in bold in the report. Where the investigator concludes that there are no failures, a statement to this effect should be made and highlighted in bold. So this seems to relate to the instruction to include a comprehensive list of failures in this report. And then over the page, please. There is this exception. Significant failures that may affect the successful likelihood of any criminal action and/or cause significant damage to the business must be confined solely to the confidential offender report. Care must be exercised when including failures within the discipline report, as obviously this is disclosed to the suspect offender and may have ramifications on both the criminal elements of the inquiry, as well as being potentially damaging to the reputation or security of the business. If you are in any doubt as to the appropriateness of inclusion or exclusion, you must discuss with your team leader. Could we have on screen, please, paragraph 78 of Mr. Whitaker's statement? That is page 20 of WITN 050-50100. Towards the bottom of the page, please. Just to clarify, the understanding of the paragraph we've just looked at, 2.15, that you're addressing here at paragraph 78, is that your understanding now, reading this document with the benefit of your current understanding of disclosure obligations, or is that how you understood the document at the time?
No, I think it was how I understood the document at the time. As I said, I was always aware in regard to disclosure that that the duty was to have an eye on it and you know, from the very beginning, and make sure that anything that passed the disclosure test was highlighted.
So what you say is this, in regard to my understanding of paragraph 2.15, I would say that any failing of the types identified in the document should be drawn to the attention of the prosecution decision maker in the report by the investigation manager, highlighting them in bold type. Over the page, please. Similarly, should a matter be progressed through the criminal courts, it would be reasonable to expect that matters highlighted in this way would be included on the relevant disclosure schedule. If there was evidence of Horizon system bugs, errors or defects, I feel that this evidence would clearly be relevant to the case and would pass the disclosure test in that it would be reasonably considered capable of undermining the prosecution case or assisting the defence. In essence, and do correct me if I paraphrase wrongly, you conclude that any serious failures would be highlighted in the offender report, even if not in the discipline report. They would be highlighted to the prosecution decision maker, who would consider it in the context of whether the prosecution test was met and decide whether the matter should be disclosed. So as such, you see no problem with paragraph 2.15. Is that right?
I think that sums it up.
Could we have back on screen, please, paragraph 2.15? That's POL 00118101. And again, page 10 of that document, please. To the bottom of the page, please. And going over actually to page 11. Looking at this wording again, do you think there was a risk that using the wording of the sort used here under a heading of failures in product integrity might be interpreted by some investigators to mean that relevant product integrity failures should not be disclosed because they might affect the success of any criminal action? That is, of course, the opposite of the test for disclosure.
I can't really comment on someone else's understanding of that. I think, speaking personally, from the very, very beginning, fairness in regards to investigations was something that I always considered. Ultimately, specifically in regard to the disclosure, if something were to undermine a prosecution or assisted defence, it needed to be disclosed, and it was my job as an investigator to gather the evidence and put it forward. It was someone else's decision to what they did with that, essentially. So, speaking from a personal point of view, that seems clear to me. And again, unfortunately, I can't speak for other people and their understanding of it.
Turning, please, to another document which Mr. Posnett asked recipients of his email to familiarise themselves with, the identification codes document. You've had an opportunity to see that document, to read
Yes.
it. I don't think we need to display it on the screen at the moment. Did you read this document as you were asked to do when Mr. Posnett sent you his email?
I don't recall specifically reading it, but if he sent me the email, there's no reason to suggest that I wouldn't have read it.
Do you recall having any concern about an identification codes document when you were an investigator?
No, because I seem to recall, and I think I've mentioned as much in my statement, that it was just something that we completed. As I say, I used a different one to the one that Mr. Posnett put forward. I never used that document. The terms on it are offensive, outdated, and as I say, I don't recall it at all. But that said, I don't recall putting up any, sending it back and saying, what's this? Which, obviously, I would like to think if it happened today, I would do.
You say at paragraph 81 of your statement that you recall as an investigator being required to include identity codes in casework reporting, which you understood to be required in the context of recording crime data and statistics to the police.
I believed it was something to do with that, yeah. Essentially, it was, as we go on, we were just been talking about compliance, it was a section that had to be filled in on the offender report. So, rightly or wrongly, I filled the section in.
Setting aside for a second the offender report, do you recall there being a specific form used by the Post Office as a non-police agency to notify the police of criminal proceedings? It
Yes.
was called a form NPA01.
Yes, there was it.
Could we have on screen, please, document reference POL 0011 8374. This is a blank copy of the form NPA01, and we can see the agency name on the top left, Post Office Limited. We can see at the top the title, Non-Police Agencies, Notification of Proceedings to Police. Then there are boxes for various identifying details of the person being charged or summoned. About halfway down the page, we can see the prosecuting agents listed as Post Office Limited Legal Services, Criminal Law Team. Then over the page, please. Right at the top, we see there are a number of options for ethnic appearance. there are 7 boxes: white European, dark European, Afro-Caribbean, Asian, Oriental, Arab, and unknown. Is this the form you use to notify the police of proceedings and to identify the identification code which applied in any given case?
This was the form that we filled in, and I think it went to a prosecution support office, and they actually dealt with the notification to the police. But it was our responsibility to fill the form in.
But is this the way that you notified police of identification codes, by reference to those options on this form?
It looks to be on the form, so obviously the question is why was it on the offender report?
So no reference to the identification codes document circulated by Mr. Posnett in May 2011 was necessary to provide identity code information to the police, was it?
It doesn't look to be the case, no.
Turning back then to Mr. Posnett's zip file of compliance documents, could we have document reference POL 00118101? This is again the guide to the preparation and layout of investigation red label case files, covering offender reports and discipline reports. Starting on page 4 of that document, please, we see, scrolling down a little, we see a preamble for the policy template of an offender report. We see there at 1.2, preamble as policy template. Going to the top of the next page, please. At the top right, we see identification code, and in brackets, numbers 1 to 7 only. So investigators were being instructed to enter an identification code limited to options 1 to 7, is that right?
Yes.
They were being provided with the identification codes document sent in the same compliance zip file, which you described as containing offensive and outdated terms. Was there any other way for investigators receiving Mr. Posnett's suite of compliance documents to interpret the instruction other than use this identification codes document to complete the identification code space on the offender report?
Well, as I said, I didn't use Mr. Posnett's information that he sent. I seem to recall I'd been an investigator for some time now, and I had numbers that corresponded with the identity codes used in the police, and it remained in my what we termed a tackle kit from an early period, and I don't recall ever changing it. As I say, some of the descriptions in Mr. Posnett's document came as a shock to me when I saw that, because I don't recall ever seeing it previously. As I say, if I got this suite of documents with this, I can only think that I did recall them, but I didn't use it. I don't remember using those terms on there at all.
Given that it was not necessary to use this document, the identification codes document, for police notification purposes, because the options were there on the face of the form, can you help us with why it was being used to populate the offender report? It may be that the answer is no.
I don't have any idea whatsoever. It certainly wasn't required. But I can say that it predated Mr. Posnet's, or this document certainly, because I do recall, I mean, as I say, I started filling in reports back in 1999, and I do recall it being on there then, and I recall it being on there ever since.
I'm sorry, what do you recall being on there then?
The space on in the report preamble for identity code.
And it's apparent from your statement that you can't assist on who might have drafted that document or how long ago that might have been.
I can't, I'm afraid, I'm sorry.
Turning please to lines of inquiry in cases where a shortage was being attributed to the Horizon system. Could we have on screen please page 22 of Mr. Whitaker's statement? Paragraph 84, you deal here with the situation when someone being investigated attributed a shortfall to problems with the Horizon system. And you say this: it is difficult to state what analysis was done by investigators of Horizon data when someone attributed to a shortage to Horizon. It depended on what had been said during the interview. If someone had stated that a loss had just appeared and offered nothing else, it was difficult to begin to find a place to start any analysis. You go on at 85, I can't specifically recall the steps I would have taken, but if the sub-postmaster could provide any relevant information about the loss being as a result of a particular product or transaction, then I feel that some analysis would have to be done in the area named. And then at 86, in regard to analysis, I always viewed that my personal role was not to provide intricate analysis of systems, and usually I would ask someone better qualified, perhaps a representative of a particular product within the National Business Support Centre, a Pole security and analyst, or on occasions Fujitsu representative to perform analysis. Should we take it from the paragraphs here that unless a sub-postmaster could pinpoint a loss being down to a particular product or transaction, then as a matter of practice, you would not request data or analysis of data from Fujitsu as part of your investigation?
I don't think that I would have at the time.
Also, in general terms, is it right that you would only carry out fairly basic analysis of data produced by Horizon, such as comparing cash-on-hand figures to previous cash accounts or declarations?
I would.
You say at paragraph 88 of your statement that early on after Horizon was introduced, you had to send away for Horizon information. What kind of information are you referring to here?
I recall just sending away for more detailed analysis of Horizon. I think on specific data sets and things like that. It depended what was I was looking into at the time. As I say, my role was to gather evidence, so I thought, if someone had said in interview that there was the loss stemmed from post office card account or whatever, I would sort of follow that trail and say, right, well, we need to have a look at post office card account. What specifically are you looking at, and then send away for that information and see if there were any anomalies that would support a line of inquiry.
And in the context of paragraph 88 here, you say that changed in that you at some point gained remote access to Horizon information via a portal on your computers where information could be downloaded directly to you?
Yes. we could examine cash accounts. I can't recall how up to date they were. They might have been a week behind or something like that. But I do recall being able to certainly have a look at cash accounts through this portal on our laptops.
And just to be clear, by remote access, do you mean that you could download and view data rather than alter that data in any way?
Yes, it was just viewing what had already been put on the system.
In respect of ARQ requests, you deal with this at paragraphs 90 and 91 of your statement. Over the page, please, page 23. Should the chair understand from these paragraphs, and perhaps we'll read those out, paragraph 90, I cannot recall arrangements between POL and Fujitsu in respect of the provision of ARQ requests, though I do not feel that they were provided as a matter of course for losses attributed to an unexplained Horizon shortage. I vaguely recall also that Fujitsu may have charged POL for provision of some ARQ information after a certain number of requests. However, I don't not recall what the number of requests before that cost began. Also, I don't recall that I ever consciously considered this in any ARQ request I might have made. At 91, I recall that ARQ data might be required if a case was committed for trial following a not guilty plea at magistrates' court. It may have been requested at this stage, perhaps by the reviewing lawyer in their advice. If this ARQ data was part of the evidence, then I feel that it would be disclosed to the sub-postmaster's legal team at the relevant point prior to the trial as part of the evidence. Should the chair understand from this that, generally speaking, ARQ data would not be sought as part of an investigation, but might be if a case was committed to trial following a not guilty plea?
In the main, yes. I don't think exclusively so. And I can only speak from the investigations that I did. Specifically, if you were looking, if an investigator potentially was looking at an office for who they suspected of doing certain things, before an interview took place, they may want to get some information, so they could have sent away for those ARQs. I would say that in the main, though, that sort of information would generally wait until we had to put together a committal file and rely on the evidence, and then obviously any evidence that we relied upon would be disclosed to the defence.
At paragraph 92, you say this: that said, I feel that in investigating cases, if it sufficed, I would often be satisfied with a catch-all statement to say that the Horizon system was in good working order at the time and did not throw up anomalies. If then directed to obtain something in more detail by legal services, I would go ahead and obtain whatever they had requested. Who would provide this kind of catch-all statement, and in what context?
I recall it was always someone within Fujitsu. I think the person changed throughout the time, and as I say, from my point of view, I was an investigator. I was gathering the evidence. Against the backdrop of believing that Horizon was robust anyway, so I would make the request to, I think through a single point of contact within our organisation, I would make the request to Fujitsu, and they will provide I say what I've termed a catch-all statement, which is a statement to say that you know, that the Horizon system at a particular office appears to be in good working order, and there's no reason that it should throw up anomalies. That sort of that's the sort of. It wasn't for me to request that statement; it was for them to give me that statement. You know.
In cases where you obtained a catch-all statement, did this mean that no case-specific analysis of the available data was conducted by anyone from Fujitsu?
I don't know what Fujitsu did to produce the statement. And as I say, I would ask that in the first instance in putting together a file potentially for a committal, putting together a committal file. As I say, if that had been reviewed by the reviewing lawyer or by counsel, and they felt that it wasn't specifically what they wanted in how they were going to run the case, then they would come back to me, and I would make the request for a statement to, if a statement could be obtained, to say whatever was required.
And you say at paragraph 93 that you recall Andy Dunks being someone who was called upon to assist in prosecutions. Is that right?
I do. I recall Andy Dunks, and I think since writing this statement, I do recall Penny Thomas, I think, may have been someone else.
I'd like to turn, please, to your involvement in the prosecution of David Blakey. You drew the distinction in your witness statement to the inquiry between shortfall cases where someone could provide relevant information about the loss as being as the result of something particular product or transaction, in which case you might have done some further analysis, and cases where someone was only able to say that a loss appeared and they could not explain it, in which case you would not, generally speaking. David Blakey's case was one where he could not explain how the loss had appeared, wasn't it?
Yes.
Do you remember Mr. Blakey and his case now?
From viewing the documentation, I've certainly got an understanding of it. In regards to the events, I do recall attending Ryby Square Post Office in Grimsby. I recall certain aspects of it, but certainly not a full narrative of every aspect of it.
You deal with your involvement in this case starting at paragraph 124 of your statement to the inquiry. Do feel free to refer to that statement if you need to. You first became aware of the case on the 13th of May 2004, on the day an audit was conducted at the Ryby Square branch. Is that right?
Yes.
Am I pronouncing that branch correctly?
I've always known it as Ryby Square, yes.
You've set out the circumstances in which this case was allocated to you in the offender report you authored dated the 25th of May 2004. Could we have that on screen, please? The reference is POL 000-44818. Turning to page 6 of that document, please, and scrolling down. We can see your name at the bottom of the report. Going back to page 2 of the document, please. We see the sub-postmaster's name, Gillian Blakey. That was Mr. Blakey's wife.
That's correct.
And the date you wrote the report, a little further down, 25th of May 2004. In terms of the circumstances leading up to your involvement, you said this. On 13th of May 2004, members of the audit team attended Ryby Square SPSO Grimsby FAD code 202311. The audit team gained entry to the office at approximately 08:20 hours. At this time, Gillian Blakey, the sub-postmaster and person named in the second preamble to this report, was asked to produce all cash stock and vouchers proper to the audit. As the audit team were awaiting the opening of the office safe, David Blakey, Gillian Blakey's husband, and offender named in the first preamble to this report, attended the office and spoke to all three members of the audit team. At this time, he informed them that there would be a shortage of cash in the post office of some £60,000. He said that this was due to cash going missing from the office over the last few months. Glenn Morris then asked Mr. Blakey to write and sign a brief statement outlining what he had just told them. The members of the audit team then contacted their management, relayed the information of the morning to that point, and continued with the audit. Just pausing there, did it concern you to find that the auditor had, on the spot, asked Mr. Blakey to write up and sign a statement?
It didn't concern me. I'm not an auditor and never have been an auditor, but I think I recall that being their standard procedure. If a disclosure was made in relation to the one such as Mr. Blakey was making, I believe that their instruction was to write that down and get the person making the disclosure to them to sign to say as much.
So it was practice to seek a signed account from someone before they'd had the opportunity to consider the position or take legal advice.
It was not something that we'd specifically asked anybody to do, as far as I recall. But it was something that the auditors did.
The auditors aren't trained, are they, in the conduct of criminal investigations?
The auditors are auditors.
So the safeguards of an interview aren't present in those circumstances, are they?
No, but I wouldn't say that it was an interview. In respect to that, whatever the auditors took would then be taken into the interview, where in this case, Mr. Blakey would have had the provisions of the caution and the provisions of having a solicitor present if they wished to. So at that stage, it was just a piece of paper that had been written, albeit an important piece of paper. It became obviously more important when introduced into evidence and discussed after the caution.
What were you told about the circumstances in which this note came to be written?
Just what was reported in the report. I say I don't recall specifically, but I don't doubt what was written in the report at the time, that it appears the auditors asked for all cash and stock to be produced, which is something that they would normally do. And at that time, Mr. Blakey offered his disclosure that the cash on hand figure had been inflated, and he'd been doing that. He'd been inflating the cash on hand for some time.
It may or may not be relevant for Mr. Blakey's case, but did you ever give any consideration to the possibility that an auditor may have said or done something that made a written signed note unreliable, and potentially a subsequent interview based on that note unreliable?
Potentially that could be the case, certainly. But again, that, as I've said, before, my job is to gather the evidence. Certainly, I would view that as a strong piece of evidence, and if that piece of evidence was to be tested down the line in court, as any piece of evidence would be, that's fair enough, and it would be for the court to decide whether you know, whether that evidence met the test. So if the auditor had been called to court and asked certain questions, then it may have made that unreliable. But at that stage, with the knowledge that I had at the time, as an investigator, I felt that it was reasonable for me to include that piece of Mr. Blakey's sort of statement, as it were, within the interview. And as I say, put it forward in my investigation and see where it led.
Can you recall who it was who called you about the situation? So you say in the next paragraph, the same morning I received a telephone, I assume that's a telephone call, apprising me of the situation, and along with Helen Dickinson of this department, I attended the office. Do you remember who called you?
I don't specifically remember who called me at this time. It would have more than likely been either my team leader at the time, or it could have been the auditor themselves, because often, because we worked quite closely with certain audit teams, particularly at that time in 2004, sometimes you would get a call and say, oh, you know, we've just turned up at a certain office and this has happened. And they would just let you know the circumstances.
Do you recall what they told you about what had happened that morning?
I don't specifically recall what they said, but as I say, I don't doubt what's written in the report there.
What happened when you arrived at the branch? And do feel free to refer to your report or your statement as you wish.
Well, again, I can speak in general terms. What would normally happen? I'd go to the office. I would perhaps speak to the auditor to see if anything had altered. You know, if the money had been found or anything else had. You know, if somebody else had come forward and offered a different account. According to the report here, I asked Glenn Morris that when I turned up. Glenn Morris being the auditor, he told me that that nothing had changed, but they were close to reaching a final figure, which indeed backed up what Mr. Blakey had said to him. And at that time, it appears Mr. Morris handed me the statement written by Mr. Blakey.
And what documents did you consider before you interviewed Mr. Blakey?
It would have been certainly the statement he gave to the auditors. It would have been cash accounts that were on hand at the office for previous weeks, and anything that the auditors felt relevant, you know, overnight cash holdings, evidence of that, those sort of things.
So no attempt was made at that stage to check the audit trail with Fujitsu as opposed to look at the paperwork which was available in branch?
No, this would have been, we were very much encouraged to undertake an early interview. And I would imagine that, it was not unusual to attend an office, have a quick briefing from the auditor, and be in an interview as soon as possible, and sometimes that could be as little as an hour after you turned up at the post office. So there was certainly no time at that point to make any substantive inquiries beyond what was immediately to hand at the audit. As I say, we were very much encouraged to perform early interviews.
And indeed, you interviewed Mr. Blakey on the same day as the audit, with the interviewing commencing at 13:08 hours. That's the time on the record of taped interview. And the interview took place on site at the branch, didn't it?
Yes, I believe so.
We have a record of the tape-recorded interview, which is in two parts. The first half of the interview lasted 42 minutes, according to that record, and recommenced for a further 32 minutes. Can we have on screen, please, the record of the first part of the interview that references POL 000444830? And we can see from this interview, from this record, that you are listed as the interviewing officer and also Helen Dickinson as second interviewer. Looking towards the bottom of the first page, please. It appears here, PW, 3 lines up, that you cautioned Mr. Blakey at the outset of the interview.
Yes.
And going over the page, please. Looking down that page, you went through Mr. Blakey's legal rights with him.
Yes.
Going over to page 3, please. And looking at that page, what was Mr. Blakey's decision on whether to have a solicitor present?
I think he actually says, no, I'm fine, honestly.
And page 4, please. Towards the top. What was his decision on whether to have a friend present?
He declined the offer of a friend to attend the interview.
This was the first time he was being told that he was the subject of a criminal investigation by the Post Office, several hours after the audit had commenced. And he was required, wasn't he, to take a decision on whether to have a solicitor present pretty much on the spot, wasn't he?
Well, it was explained to him that he could have a solicitor present if he wished. So,
what would the alternative have been to the interview going ahead then, immediately?
if Mr. Blakey had decided that he wanted a solicitor present, and he expressed that to us, we would have halted the interview at that point until such a time as he'd taken legal advice, at which point a decision would be then made whether we could continue after having that legal advice, or wait until a time when a solicitor came over, or reschedule to another time.
Do you recognise that the situation Mr. Blakey found himself in was a difficult one, being criminally interviewed by his employer, that he might have felt under pressure to just press on and explain the situation as best he could?
I recognise that being interviewed for a criminal offence is potentially very distressing, I do, and difficult. However, I would suggest that the alternative would be, should Mr. Blakey have committed an offence anywhere else, potentially he could have been taken to the police station, booked into custody, and interviewed there. So it's never it's never anything other than a distressing situation. What I would say is that Mr. Blakey was interviewed at his premises. He was interviewed in a room where people that he knew were the other side of the wall, and he was given every right that he should have been given. And as I've said before, I do understand that it is very, very distressing, but I was there to investigate a criminal offence. I had reasonable grounds to suspect Mr. Blakey of committing that offence, and therefore I think I had reasonable grounds to interview him. As I say, the Post Office requested that we interview as early as possible, and Mr. Blakey could have said, that I don't want that to happen now. And I would have, if he had said that, I would have postponed it. However, he didn't, so the interview carried on.
Going back to the record of interview, the majority of this page on screen is a record of the account given by Mr. Blakey about the background to the audit. He explains that although his wife was the sub-postmistress, he would attend the office every day after he finished his work and helped out by doing the cut-off and by balancing the office on a Wednesday. About halfway down the page, Mr. Blakey explained that he always entered the figures onto Horizon and produced the office cash account. And then he, at 10:38, covered the circumstances surrounding the audit that morning, including him telling auditors that they were going to find a discrepancy. Then at 11:36 minutes, you raised the written account requested from Mr. Blakey by the auditors, and you got him to read that out. So starting at the bottom of the page, he says, yes, this is the one. About 3 months ago, money started to go missing. I covered this up hoping to replace it. My wife had been ill. I can go into more detail about that later on if you wish. I've got an appointment with the bank manager next week. I was hopefully going to take out a loan to replace it. Where or how the money's gone, I don't know. I was hoping there was an error, but it does not appear to be the case. And I wrote that briefly this morning while I was still shaking. So straight away in the note, Mr. Blakey had written for the auditors. He was saying that the money had been going missing for about 3 months, that where or how the money had gone, he didn't know. That's right, isn't it?
Yes.
At 12:55, further down the page, please. There is a summary here of what Mr. Blakey was saying. So given this is not a transcript of interview, it's a record, some bits are word for word and some bits are paraphrased. And at 15:05, you ask where Mr. Blakey thinks the money has gone. And he says, I honestly don't know. Goodness knows, I wish I did. You ask if he thinks it is a member of staff stealing. He says no, he trusts them 100%. You ask if it was errors from his staff's incompetence. He says this is a possibility. And then at the bottom of the page, I really can't see where the hell it's gone. Over the page, please. There is some discussion of Mr. Blakey's attempts to speak to the bank to get a loan to repay the money. And at 17:30, we have you summarising what Mr. Blakey had told you and noting his reluctance to point the finger at members of staff. Then at 17:40, you say this, I don't think you're telling me the truth there, are you, David? And he says, well, I don't think you're telling me the truth. It's some time ago, to be honest with you. Not particularly about that, you say. You know where the money's gone because you've been taking it, haven't you, David? Mr. Blakey says, no way, honestly, as God is my witness, no, not a chance. What was the basis for you accusing Mr. Blakey of taking the money at this stage?
I think probably at that stage because Mr. Blakey was the one who'd been doing the accounts. He'd admitted covering the shortage up. I think he didn't offer anything in regard to any of his members of staff. And what he was saying to me at that time, obviously now is different, but at that time, I thought the system was robust. I thought We were looking at a large amount of loss, and what he said to me didn't ring true. And to be perfectly honest, sometimes when you are interviewing people, a phrase such as that, "I don't think you're telling me the truth," would often sort of focus the person's mind that you know, it was an interview where accounts would be challenged, and sometimes in past interviews, having said that, some people would open up, some people wouldn't, but some people would open up, and the interview would go in a different direction.
Was there anything other than the Horizon data that suggested money was stolen by Mr. Blakey?
Well, it was the audit report. It wasn't specifically the Horizon data. I trusted the Horizon data. At that point in 2004, I think Horizon had just rolled out fully across the Post Office Limited estate, and as far as we were told, as far as we knew, as far as we were accepted, the Horizon system was a system that was infallible, as it were. So I took the audit report that there was that amount of money gone. So I trusted that. The
audit report was confirming a difference, wasn't it, between what was actually there and what the Horizon reports were saying should be there?
Yeah.
In circumstances where the only basis for there being a loss was that Horizon data, did you consider looking at the detail of the data over the last 3 months to analyse how the losses have built up to the audit figure before accusing Mr. Blakey of theft?
I wouldn't have done that in this occasion, no. But as I said, this was very, very much at the start of Horizon. Well, in answer to your question, no, I wouldn't.
You go on. So you're saying that £60,000 has gone in a matter of months and you've not drawn it to the attention of anyone, not even your wife. No, that's not true. You say that's not true. You don't run a business like that, David. So Mr. Blakey maintains his denial that he's taken any money. There's some discussion of the cash on hand figure. And going over the page, please. Slightly further down the page. Now there's some discussion of the figures. And you ask why the figures have been steadily climbing and why he's not drawn that to anybody's attention. And he says, that's my mistake. And then at the bottom of the page, you say this: I can understand that you've probably got your wife's welfare at heart, but the size of the climb in respect of this, you can't expect me to believe that you didn't know or you didn't do something about it. If it's not you that's doing it, you've got no reason to shield anybody from it. I can understand for health reasons your wife, but you can't shield this from your staff, because if it's not you stealing and you don't suspect your wife, then it's got to be your staff's incompetence or it's got to be your staff's dishonesty. And I can't believe that you haven't got them together before this point, before now, and it hasn't been you, and you've not said to them, look, we're losing money at this post office. one of you is at it, or you are all incompetent, or something in that respect. So that just doesn't ring true. And he says, you're right, I know. Further down the page, you suggest, and this is PW a little way down from 2740, is it something your wife doesn't know about? I mean, we turn up on a Thursday morning to lots of places, sub-post offices, and the stories we've heard, you wouldn't believe a lot of them. But I know people get into trouble with various things, with gambling. And Mr. Blakey says, oh no. What was the basis for your suggestion that Mr. Blakey was stealing to cover up gambling?
As I've said there, there's any number of reasons that that someone steals, gambling being one of them. There's all sorts of, and even at that point, I was probably 5 years into my Post Office Limited career. I'd heard any number of reasons why people had stolen money, and that's not in horizon losses or anything like that. It's just that you know, people's motives for stealing are very wide and very varied. Certainly, with gambling being one of them, with being with debts in private side of shops, everything that I put to Mr. Blakey as a challenge, as it were, or as an attempt to potentially for him to open up to me about this loss that he said he got no idea about, was based in other cases that I'd done or other cases that I'd heard about, and motives that people had given me and others in the past.
You go on, things that their wives or husbands don't know about, secret lives, secret mistresses. Then Mr. Blakey laughs at this suggestion. Mr. Blakey had spent a good deal of the interview to this point talking about his concerns for his wife's health. What basis did you have for suggesting Mr. Blakey was having an affair?
I was putting out suggestions there, and what's missing from this is nuance in regard to the interview. It's in black and white there. As you can see there, Mr. Blakey laughs. I don't know in one context that in what way it was delivered, other than it being in black and white on there. But again, in the past, I'd interview people and interview people where this had been a motive for stealing, because they got a secret life. So I was putting it there as an option. I was challenging his account, because his account to that point was simply that I don't know where it's gone, and that nobody knew about it other than him.
The next section is not a word-for-word attempt at transcription, but is paraphrased, and it covers you warning Mr. Blakey that it was not only you and Miss Dickinson he had to convince, and that the court could draw its own inference if, going over the page, the matter goes that far. What was the reason for saying this to Mr. Blakey?
I suppose it was a reminder of the caution. That I'd spent, what time was it there? Half an hour speaking with Mr. Blakey. As I said at that point, it's safe to say that I didn't believe what he told me. And as I say, it's in effect me reaffirming the caution to him that you know, it's quite happy for him to give those answers to me, but ultimately, if it does go that far somewhere down the line, you know, a court can draw an inference.
And you say, if you're quite happy to sit there and say that you've not stolen the money, but you've covered it up for knowing full well that it's going missing, you've not said anything to anybody, and you're quite happy to stick to that story, And Mr. Blakey says, I'm quite happy to stick to that. That is the truth. Mr. Blakey consistently resisted the suggestion he was lying throughout the interview, didn't he?
Yes.
Over the page, please, to page 10 of this document. At 38-34, we have this. PW goes through who can be ruled out of the equation and states to DB that his wife cannot be ruled out at this stage. PW states that he feels the discrepancies are down to dishonesty and that to be thorough, he may have to see all members of staff, including DB's wife. However, PW states that he feels that this can be avoided as he feels DB has something he may wish to tell PW. Mr. Blakey says no. Was this an attempt to put pressure on Mr. Blakey to say he had taken the money to avoid you speaking to his wife?
I think at that stage, as I say, I didn't believe what Mr. Blakey was telling me, and let me state now, obviously that was a thought at the time. You know, in knowing what I know now, you know, absolutely and rightly so, Mr. Blakey's conviction has been overturned. However, at that time, I didn't believe him. I could tell that he cared about his wife. And again, I just thought I'd give him an opportunity to tell me, because I thought he'd stolen the money. I did think he'd stolen the money, so I thought I'll give him an opportunity. A last opportunity, I suppose, if you like, if he wanted to consider that.
Towards the bottom of this page, please. Mr. Blakey accepts what you put to him about the cash account. You say, so this account is a false account, and he says it is. So at this stage, you had an admission of a false account, but on the basis that Mr. Blakey was experiencing unexplained discrepancies from what he was saying.
Yes.
Were you conscious at the time of the interview that without an admission of theft in this case would be hard to prove?
I think that's safe to say, yes. Yeah.
Did that inform your approach to the interview in any way?
Well, I think it's from an investigations point of view, rightly or wrongly, you probably always feel a little bit better if you get an admission on tape under caution, because obviously that the evidence of that is pretty compelling evidence. So yes, I mean an admission of theft would have, from the post office's point of view, wouldn't have hurt.
Could we have back on screen, please, Mr. Whitaker's report of the 25th of May 2004. The reference is POL 000-44818. And it's page 5 of that document, please. And you deal on this page with the further steps that you took after interviewing Mr. Blakey. In summary, is it fair to say that the further steps in the investigation consisted of interviewing Mrs. Blakey, 2 members of Mr. Blakey's staff, Mr. Blakey's mother, who helped out with the private side of the business, and a recently retired member of staff? do take a moment to look down that page if you need to. You can scroll down.
As I say, I don't recall, but if that's what the report says, I've got no reason to doubt that.
And in addition, you started making inquiries to see whether Mr. Blakey was attempting to get a loan. So going over to the top of the next page, please. So this is the penultimate paragraph here. You were making inquiries with the Royal Bank of Scotland to establish the Blakey's financial position, and if David Blakey had approached them for a loan. And you were also seeking to establish whether Mr. Blakey had been made redundant. In terms of the members of staff you interviewed, it's right, isn't it, that none of them could shed any light on where the money had gone?
I don't recall that they did, no.
In terms of Mrs. Blakey, we have a summary of key points from her interview rather than a fuller record of tape-recorded interview. Could we have that summary on screen, please? It's POL 30444829. This is a one-page summary of an interview, which, scrolling down to the bottom, please, appears to have taken nearly 42 minutes. Is that right?
That looks to be right, yeah.
And one of the points recorded at 22:54 is summarised in this way. GB states that David has never approached her to tell her of money missing, and she was under the impression that the office was having some superb balances. One thing that did surprise her was 1 week when the office got around £1,000 back from a gyro error, but upon checking the account it showed a nice balance. Then at 24:50, GB states that she does worry when the office receives large error notices. Just pausing there, did you understand what she was referring to by error notices at that time?
Yes.
Then at 29 minutes, GB states that she doesn't think David has stolen the money, as she feels that she would have seen £60,000 added to their lifestyle. Do you recall now these issues being discussed in the interview?
I don't recall. I don't recall the interview at all. But as I say, I've got no reason to question what's been written on the document there.
Mrs. Blakey has given a witness statement to the inquiry, and in it she covers her interview with you. Could we have Mrs. Blakey's statement on screen, please? The reference is WITN 023-10100. And page 8 of that document, please. Starting at paragraph 39. She says, I was interviewed the same day, straight after my husband's interview. Mr. Whitaker first asked me how I was doing, whether I was all right. I told him that I was okay, but in fact I was miserable. He then asked if I thought my husband had stolen the money. I told him emphatically that David had not stolen anything. Then at 40, Mr. Whitaker then suggested that David may have a secret life and that he may have been gambling, and suggested that he may have been unfaithful. I did not process the suggestion at the time, as I was simply despairing. David has since told me that Mr. Whitaker had suggested to him that he had been having an affair. Do you recall making that suggestion to Mrs. Blakey? It may follow from your earlier answers that you don't.
Again, I don't recall, but there was evidence certainly that I said it to Mr. Blakey, and I don't recall in Mrs. Blakey's, the document that showed Mrs. Blakey's interview, whether it's in there, but you know, based on what's been said, I've got no reason to doubt that some inquiries were made along that line, clumsily and not very good. And if it helps, I apologise for that now, but I'm sure it doesn't help. But as I say, based on my role there and what I was there to do, Mr. and Mrs. Blake had been employed by Post Office Limited to safeguard public money. The evidence available to me at that time suggested that over £60,000 of that money was no longer there. The replies that I were getting that you know, it may have been staff, it may not have been staff. So I tried to follow those. I tried to follow that evidence, but essentially it was Mr. and Mrs. Blakey who were the figureheads and the ones that ultimately ran that office and essentially they were the ones that if it had been a member of their staff, as Mr. Blakey was doing the accounts, it perhaps would have been known to him. So the only avenue that I could go down was that it was either Mr. Blakey, Mrs. Blakey, or them together. That's how I felt. And as I say, Mr. Blakey very resolutely and very rightly denied it all the way along, as did Mrs. Blakey, excuse me. So essentially, that's where the investigation went. But to explain a little bit, my view was that, or how I tried to approach these sort of losses or losses within the post office, is that you know, £60,000 in this case was a lot of money, and somebody has to actually physically take that from the post office drawer, presumably secrete it somewhere, get it out of the building, and then use it. So I always try to have that at the back of my mind, and I think I've talked in my statement about means, motive, and opportunity. Certainly, the means and the opportunity were there for Mr. and Mrs. Blakey, and again, I had to explore a motive, as I've just said, very, very clumsily, and regrettably now. And I hope that I wouldn't do that now, but at the time I did, which I apologise for.
At paragraph 41, Mrs. Blakey says this: I asked Mr. Whitaker it could be any problems in Horizon or computer error. He gave me a long, surprised look and simply said no. Mr. Whitaker told me that no, someone has stolen it. Do you recall Mrs. Blakey asking whether there could be any problems in Horizon or computer error?
I don't recall that at all, but I've got no reason to suggest that she didn't. And my reply from that would be consistent, as I say, from the line that I was told within Post Office Limited that the system was not at fault and was never at fault.
Did it occur to you at any point that there might not be a real loss in this case?
I would say at that time, definitely not. And that's based on, as I say, the line that was given to us, that Horizon was not, was certainly without fault. Sorry.
Did you, at any stage in your investigation, request more detailed audit data from Fujitsu or ask Fujitsu to investigate to get a clearer picture of how the final apparent shortfall figure had been reached?
I can't recall. I don't think I would have done, because as I mentioned in my statement as well, we were encouraged to get an early interview, and going back to compliance, one of the things was that very, very soon after an interview, we were expected to get a file in, and that was for early advice. Quite often, that could be stalled if you had investigations, probably like this did, where you had to go out and speak to witnesses. But I would imagine that I would have got the file in very, very quickly and then waited for any advice to come back from the legal services. And if nothing came back from the legal services with regard to obtaining any other information or to pursue any other lines of inquiry, I don't think I would have.
Do you accept that it was a reasonable line of inquiry in this case to look more closely at the audit data?
In hindsight, absolutely. At the time, I would say no. Again, the audit data, I trusted the audit team. They were professionals. I got a statement from the audit team, I seem to recall, I normally would, producing the audit and saying that the audit was the results of the audit were as they were. So as regards the auditors, again, as I say, my role was to gather evidence. I wasn't an auditor, so I spoke to the auditor. I got a statement from the auditor to give me that evidence. And again, that evidence would have been challenged in court had it got that far, and that evidence would have been tested, and the auditor's account would have been tested. But I saw my role as to gather all these different strands of the investigation together and present that, the audit being one of them. And if the auditor said the audit was fine, I wasn't an auditor, so why would I suggest that it wasn't?
You say at paragraph 60 of your statement that you were bound by timescales for completion of a case file, and you think it may have been 2 weeks or thereabouts from interview to the expected date that the file was submitted for charging advice. Did this, whether in relation to Mr. Blakey's case or any other case, ever impact upon your decision-making in terms of sufficiency of investigation?
No, because I think to hit compliance, that was they expected the case to be in under those tight timescales. However, if it was obvious that you had significant inquiries to perform, I think you were given time to do that. Although I'm just trying to recall, it might be that you put the file in anyway and then just listed that you still had other stuff to do. So I just recall that, as I say, in terms of compliance and the importance that was being put on compliance, we were encouraged to get the file in within the timescales that they'd said. But there was provision if it ran over, sorry.
So I have 5 more minutes on Mr. Blakey's case, and I do have several other short topics to cover. I'm in your hands as to whether I finish that 5 minutes before we take the lunch break. I'm sorry, sir, I think you were on mute.
Yeah, finish the 5 minutes.
Thank you, sir. After you sent your report to the criminal law team, it appears that Jarnell Singh provided advice on the case by way of a memo dated the 23rd of June 2004. Could we have this on screen, please? The reference is POL 000-44835. This memo was sent to S&A Casework. Can you explain, please, which team that was? Was it simply the casework team?
I think it was just the casework. It's whatever it was called at that point, unfortunately.
And it was copied to you. Was that standard practice that the legal advice would be copied to the investigator in the case?
Yes, I think it was.
And the first paragraph of this reads as follows. In my opinion, there is sufficient evidence to afford a realistic prospect of conviction for Mr. Blakey for an offence of theft with a low prospect of success, and for false accounting with a high prospect of success. Clearly, in the absence of any admissions from Mr Blakey for theft of the £64,435.24, then we will need to eliminate the involvement of Mrs Blakey and other members of staff, and they will need to give evidence, if they can do so, to implicate Mr Blakey in the preparation of the inputs of all the daily figures for the office on the Horizon system, and that each week he completes the office balance and subsequently produces and signs the weekly cash account, and the other members of staff do not perform any of the accounting procedures at the office. This has been accepted by David Blakey. This fact needs to be confirmed in witness statements. The witnesses will need to confirm that they did not steal cash or falsify the accounts. Once we can get these statements, then I would confirm that there would be a good prospect of success to prosecute Mr Blakey for theft. The case will further be strengthened by the further inquiries which are in hand in relation to his finances. So based on the evidence to that date, Mr Singh was saying there was a low prospect of a theft conviction. In the event, Mr Blakey was prosecuted for theft and 6 charges of false accounting. What was your role in relation to the prosecution?
I think that answers something that I was speaking about just now, in that it looks like I got the file in to Mr Singh, and he came back and asked for evidence from assistants, and I believe in this case I went out and took statements from assistants. So I would have got those and submitted them back to Mr Singh, who would have assessed that evidence based on those witness statements, and suggested a theft charge along with the false accounting charges. I think then it was normally up to the investigator to lay the information at court, to obtain summons and to serve summons, and then after that, if once the case was reviewed by counsel, whether there were anything that any further inquiries or any other information that counsel required, it was probably up to the investigator to obtain that. And then at court, it would have been, I would have attended court just in a support facility there to answer any questions as required. Obviously, if I was a witness, I'd have to sit outside of the court. So it was just a supporting role, really.
You were informed of the outcome of the case by way of a memo dated the 24th of March 2005. Could we have that on screen, please? The reference is POL 30/44357. And scrolling down a little, we can see from this document that Mr Blakey pleaded guilty to the 6 false accounting charges, that is counts 2 to 7, and the theft charge was left to lie on the file. Going please to page 2 of this document towards the bottom, there are some comments. Although the judge stated that the defendant will have to repay the £64,000 to the post office at some point, no formal order for compensation was made. Over the page, please. The defendant was ordered to pay prosecution costs of £1,000 at the rate of £50 per month, the first payment to be 4 weeks from the 25th of February 2005. Civil recovery of the outstanding amount should be considered. And this memo is signed off by Phil Taylor, a legal executive within the Criminal Law Division. You say at paragraph 168 of your statement to the inquiry that during prosecution, at an early stage, the post office appeared keen to take a plea deal where the false accounting charges were admitted, with the theft charge not being taken forwards. You then suggest at paragraph 169 of your statement that a sub-postmaster being convicted of any criminal charge would mean that the post office was able to dismiss the sub-postmaster and recoup their perceived loss under the sub-postmaster's contract without evidence of the robustness of the Horizon system ever being truly tested. Was the prospect of civil recovery a factor which impacted upon decision-making on the charges which were pursued in this case, as far as you're aware?
I can't say it was as far as I was aware. I made those observations in my statement just from the amount of times that it happened. It seemed to be a regular occurrence, but I was never involved in any of the sort of background work with regard to what was accepted, what was not accepted, in regard to pleas. But it just seemed to me that it happened lots and lots and lots, and you know, the post office always had the fallback that that as a postmaster convicted of a criminal charge, you know, they could be dismissed, and again the extra fallback of under the terms of the contract they would be able to recoup losses.
You have included at paragraph 158 of your statement some reflections on Mr. Blakey's case. Is there anything you want to say now about those reflections?
Well, essentially what I've said there, I recognise that it must have been extremely distressing for Mr. Blakey and his family, for him to hear my dismissal of his now known to be truthful explanation. But I mean, I go on in the statement to explain why I did some of the things that I did in regard to him, particularly in regard to you know, challenging him and challenging his account. But they were genuinely, as I've said in my evidence prior to this, they were genuinely reasons that I'd heard before. So again, reflecting on that, perhaps, you know, this bias, albeit unconsciously, may have been in play as I investigated the incident. And as I say, I apologise for the way that you were treated.
So those are all the questions I have on Mr. Blakey's case. Shall we take lunch at that point?
You shall, but I'll just ask one question, if I may, that's occurred to me. Mr. Whitaker, in the memorandum which you were shown a few minutes ago, from Mr. I think it was from Mr. John L. Singh. It may have been Mr. Taylor, but I think Mr. John L. Singh. There was reference to investigation in Mr. Blakey's financial affairs. All right.
So yes.
And I assumed that was because I've assumed there were two strands to that. One, to check whether what he had said about applying for a loan was accurate. But secondly, to see whether there was any possibility of tracing the money which you believed had been stolen.
So in regard to 2004, when this incident happened, I don't think I would have had an eye on the proceeds of crime or anything like that. I think I recall that in his interview, Mr. Blakey had said that he'd made attempts to get a bank loan to feed money back into the post office to cover the losses. And I believe my investigations with the bank at that time would have been solely to examine that line of inquiry.
Yeah, well, it wasn't proceeds of crime so much I had in mind when I used the word trace. The best way of proving that Mr. Blakely, or for that matter anybody else, had stolen the money is if you were able to discover some or all of it. So I wondered what, if any, steps you took in order to find the money. Because as you've correctly observed, £60,000 or thereabouts in 2004 was a very substantial amount of money.
Yeah, sir, quite often, again, speaking historically with regard to a lot of post office cases, quite often it was through business failings, paying staff, things getting on top of people.
Sorry to interrupt you. I'm not
Sorry, sir.
actually talking about the motive for it. I'm actually talking about investigating where the money had gone. And the possibilities are, there are a number of them, and you mentioned some of them in interview. But what I want to know is whether you or anybody else in the investigative team followed up on that and tried to find out where the money which you believed had been stolen had actually ended up.
I think there may have been questions asked of witnesses to see about lifestyle changes and that sort of things, but probably beyond that, I'm afraid not, sir.
All right, thank you very much. Yeah, we'll take lunch now. What time should we start again, Ms. Price?
I'm looking over at the stenographer. If we were to have 55 minutes, would that be... if we come back at 10 past, in that case, sir?
All right, thanks very
If
much.
my watch is right, and it's now 15:15.
All right. So 10 past 2, everyone.